Question 1. During a comprehensive review of a process that needs improvement, a company discovers that a competitor has recently registered a trademark that is nearly identical to its long-standing unregistered brand name. The company has been using this name in commerce for over 15 years and has strong consumer recognition. Which of the following legal principles would provide the company with a basis to challenge the competitor's registration? A. First to file rule. B. First to use doctrine. C. Descriptive fair use. D. Madrid Protocol priority claim. Answer: B. First use doctrine. Explanation: in the United States, trademark rights are primarily based on use in commerce rather than registration. Under the first use doctrine, an entity that has continuously used a mark in commerce before another party files for registration typically holds superior rights. The Lanham Act 15 U.S.C. SS 1051 et seq. recognizes that common law trademark rights arise from actual use rather than mere registration. A first to file rule is incorrect because while some countries follow first to file system, the U.S. prioritizes prior use over mere filing. C. Descriptive fair use applies when term is used in its ordinary descriptive sense, not as brand identifier. This does not apply in cases of direct challenge to trademark registration. D. Madrid Protocol priority claim allows an international applicant to claim priority based on foreign filing, but it does not override common law rights established through prior use in the U.S. Thus, the company could initiate an opposition or cancellation proceeding under 15 U.S.C. SS 1064, citing its superior common law rights. Question 2. When implementing new protocols in a shared environment, an international corporation discovers that one of its subsidiaries has licensed a trademark without proper quality control provisions in place. What is the most significant legal risk associated with this improper licensing practice? A. Loss of federal registration due to lack of distinctiveness. B. Trademark abandonment due to uncontrolled licensing, naked licensing. C. Inability to enforce the trademark in international markets. D. Mandatory reapplication for registration in all jurisdictions. Answer: B. Trademark abandonment due to uncontrolled licensing, naked licensing. Explanation: a trademark owner must maintain quality control over licensees to preserve trademark rights. Naked licensing occurs when a trademark owner allows third parties to use the mark without adequate supervision or quality control, leading to a loss of distinctiveness and potential abandonment of rights. Lanham Act 15 U.S.C. SS 1127. Courts have ruled that failing to control the use of mark can result in complete loss of rights, as seen in Free Cycle of LV. Free Cycle Network, 9th Sir, 2010. A loss of federal registration due to lack of distinctiveness is incorrect because distinctiveness is evaluated at the time of registration, not necessarily impacted by failure in licensing oversight. C. Inability to enforce the trademark in international markets is incorrect because while quality control is important, international enforcement depends on national laws and treaties like the Paris Convention and Madrid system rather than licensing control issues. D. Mandatory reapplication for registration in all jurisdictions is incorrect since reapplication is only required in cases of abandonment, cancellation, or failure to renew. To avoid the risk of naked licensing, trademark owners must enforce written quality control provisions in licensing agreements, ensuring continued consumer association with the original brand's reputation. Question 3. In a high-stakes environment where multiple challenges arise, a luxury fashion brand discovers that a competitor has started selling handbags using a strikingly similar shape and color combination to its best-selling product. The brand has never registered this specific design as a trademark, but argues that consumers strongly associate it with their products. Under U.S. trademark law, which legal doctrine provides the best basis for enforcement in this scenario? A. Trade dress protection. B. First sale doctrine. C. Genericism doctrine. D. Functionality doctrine. Answer: A. Trade dress protection. Explanation: trade dress protection under Section 43A of the Lanham Act 15 U.S.C. SS 1125A allows brands to protect the distinctive appearance, shape, and overall look of product even if it is not registered. Courts have ruled in favor of trade dress claims when design is non-functional and has acquired secondary meaning, meaning that consumers directly associate the design with the specific brand. This was emphasized in 2 Pesos Inc. v. Tocqueville Inc. 1992, where the Supreme Court upheld dress protection without requiring registration. B. First sale doctrine is incorrect because it applies to the resale of genuine products, not to the unauthorized copying of distinctive design. C. Genericism doctrine is incorrect because it pertains to whether trademark has become generic. G. Escalator or aspirin, not to product design disputes. D. Functionality doctrine is incorrect because if the handbag design is deemed functional, i.e., essential to product use or affects cost quality, it would not qualify for trade dress protection. However, if the design is purely aesthetic and serves brand identifying function, it may be protected. The luxury brand can file trade dress infringement lawsuit and seek an injunction and damages under U.S. trademark law. Question 4. In a high-stakes environment where multiple challenges arise concerning brand identity, a multinational company is expanding into multiple jurisdictions and faces trademark disputes in different legal systems. One major concern is how to secure protection for its marks in multiple countries while ensuring brand consistency. The company is particularly interested in leveraging international agreements and registration systems to streamline this process. Which of the following legal frameworks would be most effective for the company to achieve its goal? A. Madrid System for International Registration. B. Paris Convention for the Protection of Industrial Property. C. European Union Trademark UTM System. D. Uniform Domain Name Dispute Resolution Policy. Answer A. Madrid System for International Registration. Explanation: the Madrid System is the most efficient mechanism for a multinational company seeking to register its trademarks in multiple jurisdictions with a single application. This system, administered by the World Intellectual Property Organization (WIPO), allows a company to file one international application and designate multiple member countries for protection. It streamlines the registration process and reduces administrative burdens. The Paris Convention (B) ensures national treatment, meaning each country applies its own laws to trademark applications, but it does not provide a centralized registration system. The UTM system (C) is beneficial for protecting trademarks within the European Union, but it does not extend beyond the EU. The other D deals with domain name disputes, not internet trademark registration. Thus, the Madrid system is the best option for securing protection in multiple jurisdictions while maintaining brand consistency. Question 5. While investigating a complicated issue between different market competitors, a company finds that a newly launched competitor is using a logo strikingly similar to its registered trademark. The company claims that this is an instance of trademark infringement. To succeed in an infringement lawsuit under U.S. trademark law, which of the following factors would be the most crucial in determining liability? A. Whether the infringing mark is used in interstate commerce. B. Whether there is a likelihood of confusion among consumers. C. Whether the infringing mark is identical to the registered mark. D. Whether the defendant intentionally copied the mark. Answer B. Whether there is a likelihood of confusion among consumers. Explanation: the likelihood of confusion test B is the primary standard for determining trademark infringement under the Lanham Act 15 U.S.C. SS 1114. Courts analyze factors such as similarity of marks, similarity of goods services, strength of the mark, and evidence of actual confusion to determine whether consumers might mistakenly believe the infringer's product originates from the trademark owner. While use in interstate commerce is prerequisite for federal trademark protection, it is not the determining factor for infringement. Exact duplication of mark C is required. Even similar marks can cause confusion. Intentional copying D may support claim but is not necessary to establish infringement. Thus, proving likelihood of confusion is the key legal standard for successful trademark infringement case. Question 6. In a situation where formal requirements conflict with branding strategies, a luxury fashion house wants to register a unique color as a trademark for its handbags. However, the examining attorney at the USTA has issued an office action stating that the color is not inherently distinctive. What legal principle must the company establish to overcome this refusal? A. The color has acquired secondary meaning. B. The color is functional and necessary for product identification. C. The color is a suggestive mark that does not require evidence of distinctiveness. D. The color is naturally associated with the product category. Answer A. The color has acquired secondary meaning. Explanation: under U.S. trademark law, color marks are not inherently distinctive and must acquire secondary meaning to be eligible for protection, as established in Qualitex Company v. Jacobson Products Company, 1995. Secondary meaning occurs when consumers recognize the color as a source identifier rather than just an aesthetic feature. Functionality B is A barter registration if a color serves a functional purpose, e.g., visibility for safety, it cannot be trademarked. Suggestive marks, c. do not apply to colors, as colors are considered descriptive or generic unless they gain distinctiveness. Natural association, d. does not justify trademark protection unless backed by consumer recognition evidence. Thus, proving secondary meaning is essential for registering a color trademark. Question 7. During an emergency response where multiple areas are impacted by counterfeiting, law enforcement authorities seize a shipment of fake luxury watches at the border. Which federal agency is primarily responsible for preventing counterfeit goods from entering the U.S.? A.U.S. Patent and Trademark Office, USPTO. B.U.S. Customs and Border Protection, CBP. C. Federal Trade Commission, FTC. D. Department of Justice, DOJ. Answer: B.U.S. Customs and Border Protection, CBP. Explanation: U.S. Customs and Border Protection, CBP. B is the primary enforcement agency responsible for seizing counterfeit goods at U.S. borders under the Stop Counterfeiting in Manufactured Goods Act 2006 and the Tariff Act of 1930-19 U.S.C. SS 1526. Trademark owners can record their register marks with CBP to help detect and stop counterfeit shipments. The USDOE handles trademark registration, not enforcement. The FTC regulates false advertising and deceptive trade practices but does not police counterfeit imports. The DOJ prosecutes criminal cases involving counterfeiting but does not monitor borders. Thus, CBP plays a central role in blocking counterfeit goods from entering the U.S. market. Question 8. When implementing new protocols in a shared environment, a global corporation licenses its brand name to a third-party manufacturer. The agreement includes strict quality control provisions. Why is quality control essential in a trademark licensing agreement? A. To ensure the licensee can freely use the trademark in any manner. B. To prevent the trademark from becoming generic due to uncontrolled use. C. To allow the licensee to modify the trademark for marketing purposes. D. To meet international trademark registration requirements. Answer: B. To prevent the trademark from becoming generic due to uncontrolled use. Explanation: in trademark licensing, quality control, B, is crucial to prevent the naked licensing where trademark owner fails to oversee how licensee uses the mark. Without proper quality control, the trademark could lose distinctiveness and become generic, as ruled in Free Cycle v. Free Cycle Network 2010. Freely using the trademark without oversight weakens the brand's legal standing. Modifying the trademark, C, without authorization could lead to inconsistent branding and potential abandonment of rights. International registration, D, does not depend on quality control but on use and distinctiveness. Thus, trademark owners must enforce quality control provisions to preserve brand integrity. Question 9. When investigating a complicated issue between different market competitors, a well-established technology company discovers that a startup is using a nearly identical slogan for a competing product. The company has a federally registered trademark for the slogan and wants to enforce its rights. To succeed in a trademark infringement lawsuit, which of the following legal doctrines would the court primarily apply to determine infringement has occurred? A. The Polaroid factors test. B. The fair use doctrine. C. The Rogers test. D. The exhaustion doctrine. Answer: A. The Polaroid factors test. Explanation: the Polaroid factors test is used in trademark infringement cases to determine whether a likelihood of confusion exists between the two marks. The test considers factors such as strength of the plaintiff's mark, similarity between the marks, proximity of the product services, evidence of actual confusion, defendant's intent in adopting the mark, consumer sophistication. The fair use doctrine, B, allows others to use trademark in descriptive or nominative manner, such as factual references to product. The Rogers test, C, applies when trademark is used in an expressive work, like movie or book title. The exhaustion doctrine, D, applies to resale of genuine goods, not infringement disputes. Since the Polaroid evaluates likelihood of confusion, it is the primary standard for trademark infringement claims in U.S. courts. Question 10. While investigating a complicated issue between different market competitors, a company finds that a competitor is using a similar brand name for an online business. However, the competitor argues that it operates only in a small geographic area and does not interfere with the plaintiff's market. Under what legal principle could the competitor claim valid defense against trademark infringement? A. Common law priority. B. The T. Rose Rectennis doctrine. C. The functionality doctrine. D. The first sale doctrine. Answer: B. The T. Rose Rectennis doctrine. Explanation: the T. Rose Rectennis doctrine B is a common law principle that allows a junior user of a trademark to continue using the mark in a limited geographic area if the junior user adopted the mark in good faith. The senior user had not yet established national or local recognition in that region. This doctrine applies only in cases where federal registration does not extend priority or where the senior user had not yet entered the market. Common law priority A generally grants rights based on first use in commerce, but this doctrine refines that rule. The functionality doctrine C prevents trademark protection for functional product features, and the first sale doctrine D relates to resale of trademarked goods, not infringement defenses. Thus, the T. Rose Rectennis doctrine protects regional trademark users from liability when a senior user later expands into their territory. Question 11. In a high-stakes environment where multiple challenges arise concerning brand identity, a luxury car manufacturer wants to protect its distinctive grille design from being copied by aftermarket part manufacturers. To strengthen its legal position, the company should seek protection under which of the following intellectual property rights? A. Trade dress protection under the Lanham Act. B. Patent protection for functional design. C. Copyright protection for artistic expression. D. Right of publicity for unique brand elements. Answer: A. Trade dress protection under the Lanham Act. Explanation: trade dress protection under the Lanham Act applies to the overall look and feel of a product when it serves as a source identifier. The distinctive grille design could qualify for trade dress if it is non-functional, not essential for the product's use. Distinctive has acquired secondary meaning, used in commerce as brand identifier. Patent protection B applies if the design is fun rather than aesthetic. Copyright C protects artistic expression but not product designs used in commerce. Right of publicity D applies to personal identities, not product elements. Thus, trade dress protection is the strongest legal strategy for preventing unauthorized copies of distinctive product design. Question 12. During a major transformation where existing methods of brand enforcement need reevaluation, a company finds that an independent retailer has been selling repackaged versions of its trademarked product. The retailer claims that they have legally purchased the products and are therefore entitled to resell them under the first sale doctrine. However, the company argues that the repackaging alters the product in a way that misleads consumers, dilutes the brand's reputation. Which of the following factors is most likely to determine whether the retailer's actions constitute trademark infringement? A. Whether the retailer prominently displays the original brand name on the repackaged product. B. Whether the alterations made by the retailer materially affect the quality of the product. C. Whether the retailer has contractual agreement with the trademark holder. D. Whether the retailer has been selling the product in multiple jurisdictions. Answer: B. Whether the alterations made by the retailer materially affect the quality of the product. Explanation: the first sale doctrine allows the resale of legally purchased trademarked products without violating trademark law. However, this doctrine does not apply if the reseller's modifications materially affect the quality of the goods, leading to consumer confusion. The U.S. Supreme Court in Presto Nets Inc. v. Cutty 1924 established that minor changes that do not misrepresent the product may be acceptable, but material alterations that impact the brand's reputation are not protected by the first sale doctrine. If the retailer's repackaging significantly changes the product's quality, packaging, or consumer perception, it could lead to trademark infringement claim. Option is incorrect because merely displaying the brand name does not prevent consumer confusion if the product quality has changed. Option C is incorrect because contractual agreement is not necessary for resale claim under the first sale doctrine. Option D is incorrect because the geographical scope of sales does not determine whether the first sale doctrine applies. Question 13. While examining inconsistencies across various units of a multinational corporation, the legal team finds that a subsidiary has allowed its registered trademark to be used informally by distributors and retailers without a licensing agreement. If the corporation does not take action, what legal consequences most likely to arise? A. The trademark could be deemed abandoned due to lack of control over its use. B. The trademark will remain valid as long as the company continues manufacturing products. C. The distributors and retailers could be required to pay retroactive licensing fees. D. The company will automatically retain exclusive rights if the trademark was federally registered. Answer A. The trademark could be deemed abandoned due to lack of control over its use. Explanation. Under U.S. trademark law, a failure to police and control the use of a trademark can result in its loss of distinctiveness and ultimately abandonment. This is known as naked licensing, where a trademark owner allows uncontrolled or unregulated third-party use of its mark. Courts have ruled in cases such as FreeCycle v. FreeCycle Network Inc. 2010 that when a trademark owner fails to supervise and enforce proper usage, the mark may become generic or abandoned, leading to a loss of trademark rights. Option B is incorrect because mere manufacturing does not maintain a trademark if it is not actively controlled. Option C is incorrect because licensing fees cannot be retroactively imposed without an existing agreement. Option D is incorrect because federal registration does not automatically protect a mark if the owner allows unrestricted third-party use. Question 14. In a case where multiple parties have different objectives regarding a disputed trademark, a restaurant chain claims exclusive rights to a slogan that has been widely used by independent eateries. The chain argues that it has a federal registration, while the independent eateries claim prior common law use in their specific geographic areas. What factor is most important in determining trademark priority? A. The date the restaurant chain applied for federal registration. B. The extent and duration of use of the slogan by the independent eateries in their respective regions. C. Whether the restaurant chain has plans to expand into the independent eateries' territories. D. Whether the independent eateries have opposed the chain's trademark registration. Answer. B. The extent and duration of use of the slogan by the independent eateries in their respective regions. Explanation. Under common law trademark principles, priority is generally based on first use in commerce, not on registration. This is known as the first to use rule in the United States. A business that continuously uses a mark in a specific geographic area can have superior rights over a later federal registrant in territory. The Lanham Act recognizes such common law rights, allowing prior users to challenge federally registered trademarks. Option is incorrect because trademark rights are based on actual use, not just the date of application. Option C is incorrect because future expansion does not override established common law rights. Option D is incorrect because opposition to registration is not required to maintain local priority rights. Question 15. During the introduction of new methods where coordination between digital platforms is required, the commerce company realizes that its domain name has been registered by an unrelated third party who is demanding a large sum to transfer it. The company holds a federal trademark for its brand name. What is the best legal remedy in this situation? A. File a lawsuit under the Anti-Cyber-Squatting Consumer Protection Act (ACTA). B. Register a different domain name with a slight variation. C. Wait until the domain expires and attempt to purchase it. D. Negotiate directly with the third party to obtain the domain. Answer A. File a lawsuit under the Anti-Cyber-Squatting Consumer Protection Act (ACTA). Explanation. The Anti-Cyber-Squatting Consumer Protection Act (ACTA) 15 U.S.C. SS 1125-D provides legal remedies for trademark owners whose marks have been improperly registered as domain names by bad faith actors. The Act allows trademark owners to sue and seek domain name transfer if they can prove the domain name is identical or confusingly similar to valid trademark. The registrant has no legitimate rights or interests in the domain name. The registrant acted in bad faith to profit from the trademark. B is incorrect because using slightly modified domain may lead to consumer confusion and weaken brand identity. Option C is incorrect because there is no guarantee the domain will become available. Option D is incorrect because negotiating with cyber-squatter may encourage more abusive behavior and lacks legal enforcement. Question 16. While developing a legal strategy for product differentiation, a company seeks to protect the unique shape and packaging of its best-selling beverage bottle. The company has already secured a registered trademark for its brand name and logo. Which legal protection is most appropriate for securing rights over the shape of the bottle? A. Applying for a trade dress registration under the Lanham Act. B. Filing a standard trademark application for the bottle shape. C. Seeking utility patent to protect the functional aspects of the bottle. D. Relying on common law protections without federal registration. Answer A. Applying for a trade dress registration under the Lanham Act. Explanation. Trade dress refers to the overall look and feel of A product including packaging, color schemes, or unique product designs that distinguish it in the marketplace. Under the Lanham Act, trade dress can be registered as a trademark if it is distinctive and non-functional. 2 pesos Inc. v. Tococabana Inc. 1992. To qualify for trade dress protection, the bottle shape must either be inherently distinctive or have acquired secondary meaning, meaning consumers associate the shape specifically with the brand. Option B is incorrect because standard trademarks generally protect names, logos, and slogans, not product shapes. Option C is incorrect because utility patents protect functional inventions, not aesthetic product features. Option D is incorrect because common law rights are weaker than federal trade dress protection and harder to enforce nationwide. Question 17. In a scenario where licensing agreements are being restructured to maximize brand control, a company that owns a well-known trademark wants to license its mark to an overseas manufacturer. Which of the following contractual provisions is most critical to maintaining the validity of the trademark? A. A provision requiring the licensee to submit royalty payments on time. B. A provision allowing the licensee to sublicense the trademark freely. C. A provision requiring the licensor to exercise quality control over the products. D. A provision permitting the licensee to modify the mark's appearance in foreign markets. Answer: C. A provision requiring the licensor to exercise quality control over the products. Explanation: in trademark licensing agreements, a licensor must actively control the quality of goods or services offered under the trademark to prevent naked licensing, which can lead to trademark abandonment. Courts have ruled that failure to enforce quality control can cause a mark to lose its distinctiveness. Free Cycle Synovel v. Free Cycle Net Inc. 2010. Option is incorrect because royalty payments are financial concerns not directly related to trademark validity. Option B is incorrect because unrestricted sublicensing can dilute brand identity and reduce control. Option D is incorrect because modifying the mark's appearance without approval could lead to brand inconsistency and loss of distinctiveness. Question 18. In an effort to expand globally, a US-based company discovers that a foreign competitor has begun using a similar trademark in another country. The competitor argues that they have registered the trademark first under that country's first-to-file system. How should the U.S. company respond? A. File an opposition in the foreign country's trademark office. B. Assume that their U.S. registration protects them internationally. C. File lawsuit in U.S. federal court to block the foreign competitor's use. D. Wait until they expand into the foreign market to enforce their rights. Answer: A. File an opposition in the foreign country's trademark office. Explanation: different countries follow different trademark priority systems. The United States follows the first-to-user system where priority is based on actual use in commerce. Many other countries follow the first-to-file system where priority is based on who registers the mark first. If competitor has wrongfully registered similar trademark abroad, the U.S. company must challenge it through formal opposition or cancellation proceedings in the foreign country. The Madrid Protocol allows companies to file for international trademarks, but each country still enforces its own rules. Option B is incorrect because U.S. trademark does not provide automatic global protection. Option C is incorrect because U.S. federal courts cannot enforce trademark laws in other countries. Option D is incorrect because waiting too long could weaken the company's claim under local laws. Question 19. While analyzing risks associated with brand erosion, a multinational company notices that its famous trademark is being used on unrelated products by third parties. Even though there is no direct competition, consumers might still associate the famous mark with low-quality goods. What legal doctrine provides the strongest basis for stopping this unauthorized use? A. The doctrine of likelihood of confusion. B. The doctrine of nominative fair use. C. The doctrine of dilution under the Federal Trademark Dilution Act (FTDA). D. The doctrine of abandonment due to non-use. Answer: C. The doctrine of dilution under the Federal Trademark Dilution Act (FTDA). Explanation: the Federal Trademark Dilution Act (FTDA) protects famous trademarks from uses that weaken their distinctiveness or harm their reputation, even if there is no direct competition or likelihood of confusion. There are 2 types of dilution: dilution by blurring, weakening the distinctiveness of the famous mark, e.g., Nike computers; dilution by tarnishment, associating the mark with negative or inferior products, e.g., Gucci tobacco. The Trademark Dilution Revision Act (EDRA) 2006 reinforced protections for famous marks, requiring only that the mark be widely recognized by the general public. Option is incorrect because dilution applies even if consumers are not confused about the source. Option B is incorrect because nominative fair use applies only when using mark to refer to the actual brand, e.g. news reporting. Option D is incorrect because abandonment refers to failure to use mark, not unauthorized third-party use. Question 20. When implementing new strategies to protect a company's intellectual property portfolio, the legal team is considering issuing cease and desist letters to multiple unauthorized users of its registered trademark. What is the primary risk of aggressively sending cease and desist letters without strong legal grounds? A. It may lead to the loss of the trademark due to over-enforcement. B. It could result in a trademark bullying claim and possible legal action against the company. C. It would automatically strengthen the company's trademark rights. D. It could be seen as an admission that the trademark is weak. Answer. B. It could result in a trademark bullying claim and possible legal action against the company. Explanation. Trademark bullying occurs when a trademark owner over-enforces its rights, particularly against businesses that do not actually infringe upon the trademark. The U.S. Patent and Trademark Office, USTO, and courts have criticized companies that aggressively threaten small businesses without clear legal justification. Excessive enforcement could lead to bad publicity, countersuits, and even judicial scrutiny. Option is incorrect because over-enforcement does not lead to trademark abandonment. Option C is incorrect because trademark rights are based on use and distinctiveness, not aggressive enforcement. Option D is incorrect because issuing cease and desist letters does not indicate a weak trademark. Question 21. When assessing international trademark strategies, a company with multiple subsidiaries worldwide wants to simplify its trademark registration process. What is the most efficient way to apply for trademark protection in multiple countries? A. File separate trademark applications in each country. B. Use the Madrid Protocol to file an international trademark application. C. Register the trademark only in the U.S. and rely on common law rights. D. Apply for a U.S. trademark first, then automatically gain worldwide protection. Answer. B. Use the Madrid Protocol to file an international trademark application. Explanation. The Madrid Protocol allows businesses to apply for trademark protection in multiple countries through a single application. This system simplifies international registrations and reduces costs by centralizing the process under the World Intellectual Property Organization, WIPO. Option is incorrect because filing separately in each country is expensive and time-consuming. Option C is incorrect because U.S. common law rights do not extend internationally. Option D is incorrect because U.S. trademarks do not grant automatic worldwide protection. Question 22. When considering the enforceability of a company's trademark rights, a business discovers that a competitor is using a very similar name for a product in a different industry. The competitor argues that their use does not create confusion because they operate in an unrelated field. What factors would a court examine in determining whether trademark infringement has occurred? A. The distinctiveness of the original trademark and the similarity of the marks. B. Whether the competitor has a registered copyright on the product name. C. The geographical distance between the two businesses. D. Whether the original trademark owner has obtained a utility patent on the product. Answer A. The distinctiveness of the original trademark and the similarity of the marks. Explanation. In trademark infringement cases, courts evaluate the likelihood of confusion between two marks using multiple factors, most notably the Polaroid factors from Polaroid Corp. v. Polaroid Corp. 1961. These factors include the strength of the original mark. More distinctive marks receive stronger protection. The similar of the marks. The closer they are in appearance, sound, or meaning, the greater the likelihood of confusion. The proximity of the goods services. If the businesses operate in overlapping markets, confusion is more likely. Actual consumer confusion. Evidence of real confusion strengthens the claim. Bad faith intent of the infringer. If the competitor adopted the name to capitalize on the goodwill of the original mark, infringement is more likely. Option B is incorrect because copyright protection does not apply to names or short phrases. Option C is incorrect because geographic distance is only one factor. The global online markets reduce its impact. Option D is incorrect because patents protect inventions, not trademarks. Question 23. In preparing for a corporate merger, a company must evaluate its trademark portfolio to determine the value of its brand assets. Which of the following factors best determines the overall strength of a trademark? A. The amount of money spent on advertising the mark. B. Whether the mark is generic, descriptive, suggestive, arbitrary, or fanciful. C. The number of variations of the mark the company has used. D. How often competitors attempt to register similar marks. Answer B. Whether the mark is generic, descriptive, suggestive, arbitrary, or fanciful. Explanation. A trademark's strength depends on where it falls on the distinctiveness spectrum. Fanciful, strongest, made-up words, e.g. Xerox, arbitrary, real words unrelated to the product, e.g. Apple for computers, suggestive, indirectly describes the product, e.g. Netflix for streaming, descriptive, directly describes characteristic of the product, e.g. Cold ice for refrigeration company. These require secondary meaning to be protected. Generic weakest. Common product names, e.g. aspirin for pain relief. These cannot be protected as trademarks. Option is incorrect because marketing spend does not determine legal protection. Option C is incorrect because inconsistent use weakens trademark rights. Option D is incorrect because competitor attempts may indicate value but do not define inherent trademark strength. Question 24. While establishing brand exclusivity, a luxury brand notices counterfeit products using its registered trademark. What legal remedies are available to the brand owner under the Lanham Act? A. Only civil damages in federal court. B. Civil damages, injunctive relief, and possible criminal penalties. C. Filing a copyright claim with the U.S. Copyright Office. D. Registering the mark again with the U.S. Patent and Trademark Office. Answer B. Civil damages, injunctive relief, and possible criminal penalties. Explanation. The Lanham Act 15 U.S.C. SS 1116-1117 provides strong enforcement mechanisms against counterfeiting, including civil remedies. The brand owner can sue for damages, lost profits, and attorney's fees. Injunctive relief. Courts can issue injunctions to stop counterfeit sales. Criminal penalties. If the counterfeit goods caused significant harm, federal criminal prosecution is possible under 18 U.S.C. SS 2320. Option is incorrect because criminal penalties are available in cases of willful counterfeiting. Option C is incorrect because copyright law protects creative works, not trademarks. Option D is incorrect because re-registering trademark does not enhance enforcement rights. Question 25. When analyzing the impact of online marketplaces on trademark enforcement, what legal principle allows brand owners to hold e-commerce platforms responsible for counterfeit sales? A. The nominative fair use doctrine. B. The doctrine of contributory trademark infringement. C. The first sale doctrine. D. The functionality doctrine. Answer B. The doctrine of contributory trademark infringement. Explanation. In contributory trademark infringement, a party can be held liable if it facilitates or encourages the infringement of a trademark by third parties. The Supreme Court established this doctrine in Inward Labs v. Labs 1982. Option is incorrect because nominative fair use applies when third parties legitimately reference a brand without misleading consumers. Option C is incorrect because the first sale doctrine allows consumers to resell genuine trademarked products but does not apply to counterfeit goods. Option D is incorrect because the functionality doctrine is relevant to trademark protection, not enforcement. Question 26. When determining whether a trademark registration should be cancelled due to non-use, how many consecutive years of non-use create a presumption of abandonment under U.S. Trademark law? A. 1 year. B. 2 years. C. 3 years. D. 5 years. Answer C. 3 years. Explanation. Under 15 U.S.C. SS 1127, trademark is presumed abandoned if it is not used in commerce for 3 consecutive years and the owner lacks intent to resume use. However, the trademark owner can rebut the presumption by proving intent to resume use. Question 27. When a competitor uses a similar slogan to a famous brand's tagline, which type of trademark protection is most relevant? A. Trade dress protection. B. Certification mark protection. C. Slogan trademark protection. D. Collective mark protection. Answer C. Slogan trademark protection. Explanation. Slogans can be trademarked if they function as source identifiers and are distinctive, e.g. just do it for Nike. Question 20. When a U.S. company wants to protect its trademark in multiple countries under one application, which international treaty provides this protection? A. The Paris Convention. B. The Berne Convention. C. The Madrid Protocol. D. The TRIPS Agreement. Answer C. The Madrid Protocol. Explanation. The Madrid Protocol allows a business to file a single international trademark application through WIPO, simplifying global registration. Question 29. When an individual's name is used as trademark, what is required for protection? A. Famous person automatically gets protection. B. Secondary meaning must be established. C. Only first names can be trademarked. D. Celebrity endorsements are required. Answer B. Secondary meaning must be established. Explanation. Personal names must acquire secondary meaning to be protected, e.g. McDonald's as brand. Question 30. When a company seeks federal trademark protection for a geographic term, what is a key requirement? A. It must be inherently distinctive. B. It must have acquired secondary meaning. C. It must be a generic term. D. It must be associated with multiple industries. Answer B. It must have acquired secondary meaning. Explanation. Geographic terms, e.g. Napa Valley wines, require secondary meaning to be registered as trademarks.